Chapter 4. Legislature. The Parliament of India is supreme body in India. It is assigned with the legislative functions in India. It has both elected as well as nominated members. It represents the will of the people of India. It ensures representation from all the regions, classes and groups of India. Indian legislature is bicameral, having two houses, Lok Sabha and Rajya Sabha. The Constitution authorizes each state to choose either a unicameral or a bicameral legislature. Composition of Parliament. Parliament of India consists of three organs, viz. the President, the Council of States, the Rajya Sabha, and the House of the People, the Lok Sabha. Though President is not a member of either House of Parliament, yet he is an integral part of the Parliament and performs certain functions relating to its proceedings. In India, the President summons the two Houses of Parliament, dissolves the House of People and gives assent to bills. Though the Indian Constitution provides for the parliamentary form of government, but unlike Britain, the Parliament is not supreme under the Indian Constitution. In India, the Constitution is supreme. In England, laws passed by the Parliament cannot be declared unconstitutional, while the Indian Constitution expressly vests this power in the courts. The Indian Parliament is created by the Constitution and derives all its powers from the Constitution. The two main houses of the Indian Parliament, Rajya Sabha and Lok Sabha, are discussed as under. Rajya Sabha. Members represent the states and union territories, while the other 12 are nominated by the Rajya Sabha as the upper house of the Parliament. It consists of 250 members. Out of these, 238 President of India amongst persons with special knowledge or practical experience in the field of literature, science, art and social services. The representatives of the states are elected by elected members of the state legislative assemblies. In the union territories, which do not possess legislative assemblies, Delhi and Puducherry, these members are elected by electoral college specially constituted for the purpose. (52) The election of the members of Rajya Sabha is held in accordance with the principle of proportional representation by means of single transferable vote. The Rajya Sabha, unlike the Senate of USA, does not exclusively contain the representatives of the states alone, as there are 12 nominated members as well. Further, all the states of the Indian Union are not even given equal representation in the Rajya Sabha. The various states have been allotted seats in accordance with their population. Therefore, the representation of the state varies from 1 to 31. Qualifications. A person seeking membership of Rajya Sabha must possess the following qualifications. He must be a citizen in India. He must not be less than 30 years. Age. He must make and subscribe before some persons authorized in that behalf, by the Election Commission, an oath or affirmation asserting his allegiance to the Constitution of India and undertaking to uphold the sovereignty and integrity of India. He must possess such other qualifications as may be prescribed by the Parliament for that purpose from time to time. Term of the House. The Rajya Sabha is a permanent house and is not subject to dissolution. 1/3 of the members of Rajya Sabha retire after every 2 years in accordance with the provisions made by the Parliament by law. The members of the Rajya Sabha are elected for a term of 6 years. This arrangement ensures continuity as well as representation of the changing public opinion. Presiding officer. The Vice President of India is the ex officio chairman of the Rajya Sabha. In addition, the House also elects a deputy chairman amongst its members. The deputy chairman presides over when the vice president is absent. The chairman does not enjoy the right to vote except in case of a tie. As presiding officer, the chairman of the Rajya Sabha is responsible for maintaining order and decorum in the House and conducts the proceedings in accordance with the rules. As the chairman is not a member of the House, he is not entitled to vote, except in case of a tie. However, he General Studies, Mains, Paper 2 has the right to speak and otherwise takes part in the proceedings in the House. 1/10 of the total membership of the Rajya Sabha constitutes the quorum for holding a meeting of the House. Parliament. The Lok Sabha or the House of People is the popular house of the Indian Parliament and contains elected representatives of the people. Its maximum strength has been fixed at 552. Out of these, not more than 530 members are directly elected from territorial constituencies of the states and not more than 20 members are elected from the union territories in a manner as prescribed by Parliament by law. The number of members each state is expected to elect is determined on the basis of the population. Within the state also, the constituencies are so drawn that as far as practicable the population of cash constituency is roughly the same. At present, the parliament consists of 545 members. Out of those 530 seats have been allotted to the states, 13 seats to UTS, whereas 2 members are nominated by President from Anglo-Indian community. According to 84th Amendment Act, 2001, there is restriction to increase the number of seats till 2026. Qualifications. A person seeking election to the Lok Sabha must possess the following qualifications. He must be a citizen of India. Black Circle Lee must be at least 25 years of age. Black Circle he must possess such other qualifications as may be prescribed by the Parliament. He must not hold any office of profit under the union or state governments. Black Circle he must not be a person with unsound mind or an undischarged insolvent. He must make and subscribe before some person authorized in that behalf by the Election Commission an oath of affirmation asserting his allegiance to the Constitution of India and upholding the sovereignty and integrity of India. Term of the House. The Lok Sabha enjoys a term of 5 years from the date of its first session. The term of the House was increased to 6 years under the 42nd Amendment Act, but again it was reduced to 5 years by the 44th Amendment Act. The term of the House can be cut short if the President dissolves it earlier on the Constitutional Framework. 53. Advice of the Prime Minister. While a proclamation of emergency is in operation, the term of the House can be extended by 1 year at a time. However, the House must be dissolved within 6 months of the expiry of such a proclamation. The life of the 5th Lok Sabha was extended twice. Presiding Officer. The presiding officer of the Lok Sabha is Speaker. He is elected by the House at its first meeting of the new Lok Sabha amongst its members. In addition, the House also elects the Deputy Speaker, who discharges the duties of the Speaker during his absence or leave. The Speaker and the Deputy Speaker have to vacate their office if they cease to be members of the Lok Sabha. They can also vacate their offices by tendering resignation. The Speaker and the Deputy Speaker can be removed from office before the expiry of their term, if the House passes a resolution to this effect by a majority of the members. It may be noted that when the House is considering a resolution for the removal of the Speaker from this office, he does not preside over the meetings of the House. The same applies to the Deputy Speaker. However, no resolution for the removal of the Speaker or Deputy Speaker can be moved unless at least 14 days' notice has been given of the intention to move such a resolution. Likewise, the term of the Speaker automatically gets extended, if the term of the Lok Sabha is extended beyond 5 years. Even where the Lok Sabha is dissolved on the completion of its normal term, the Speaker stays in office until immediately before the first meeting of the Lok Sabha after the dissolution. The Speaker has the right to speak and to take part in the proceedings of the House but has to vote except in case of a tie. The Speaker and the Deputy Speaker of the Lok Sabha are entitled to a sitting allowance and the constituency allowance as applicable to members of Parliament. In addition, they are entitled to a sumptuary allowance. They are exempted from tax for the rental value of the furnished houses provided to them. They are also entitled to medical and travel facilities. The salaries and allowances of Speaker and Deputy Speaker are charged on the Consolidated Fund of India and are not subjected to the vote of the Parliament. Working of the Parliament. The Parliament works in accordance with the rules and regulations formulated by the Parliament in this regard. The power to summon the session of the two Houses of Parliament rests with the President, who can also discontinue a session of the two houses and dissolve the Lok Sabha. However, under the Constitution, it is obligatory for the President to summon at least two sessions of the Parliament every year, and the gap between these two sessions should not be more than 6 months. In actual practice, the Indian Parliament has 3 sessions in a year. The sessions are generally held in months of January to February, July, August, and October to November. These are named as budget session, monsoon session, and winter session respectively. Generally, the first session of the Parliament every year starts with address of the President. In this address, the President makes a review of the conditions prevailing in the country and outlines the policy and program of the government during the ensuing year. This speech is in fact prepared by the Prime Minister and is approved by the Cabinet. The President simply reads it out on the floor of the Parliament. After due discussion, the Parliament passes a vote of thanks to the President, which has same effect as the approval of the policy of the government. But before the final vote of thanks is passed by the House, a lot of discussion takes place on government's policy. Amendment to the vote of thanks. If the vote of thanks is not passed in the Lok Sabha, then it means that the government has lost the majority. If it got amended or not passed in the Rajya Sabha, then it is not a good sign for the reputation of the government. In past few years, it has been amended twice in the Rajya Sabha. Legislative procedure. An identical legislative procedure is followed by both the houses. Under the provisions of the Constitution, a bill other than the financial or money bill can originate in either House of Parliament. '54. It is submitted to the President for his assent only after it has been passed by both the houses. However, the two houses are not able to agree on a particular bill. The issue can be resolved by the President by summoning a joint sitting of the two houses. At such a joint sitting, the decision is taken by majority of the members present in both the houses. An ordinary or non-money bill has to pass through the following stages in each house. First reading stage. At this stage, the mover of bill reads out the title. Generally, he makes a brief speech explaining the aims and objectives of the bill. This is followed by a vote of the House and the bill is published in the Gazette. The bills introduced by the ministers, viz. Government bills, are straightaway published in the Gazette. Second reading stage. After some time, the second reading of the bill takes place. At this stage, the general principles of the bill are discussed. It is noteworthy that the bill as a whole is discussed and no amendments are permitted at this stage. Committee stage. After the second reading, the bill is referred to the appropriate committee of either House or Joint Committee. The committee considers the various provisions of the bill thoroughly and suggests suitable improvements and amendments. Report stage. After the committee has completed its deliberations, it submits a report to the House. This report is then thoroughly discussed by the House. Discussion is held on various clauses of the bill and separate voting takes place on each clause. At this stage, amendments can be proposed to the bill. Third reading stage. At this stage, only general discussion on the bill takes place and the final voting on the bill is held. No amendments can be introduced at this stage. General Studies, Mains, Paper 2. Stage of passing by other House and President's assent. After the bill has been passed by one House, it is transmitted to the other House. Therefore, it has to go through all these stages once again. If the other House approves the bill, the same is sent to the President for his assent. On the other hand, if the other House refuses to pass the bill or proposes certain amendments, which are not acceptable to the first House, the bill is not passed. The differences may be resolved by the President through a joint sitting of the two Houses, if government so desires. Financial procedure. The procedure for the enactment of the money or financial bill is slightly different. It can be introduced only in the Lok Sabha and on the recommendation of the President. Only the ministers can introduce money bills. After a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its recommendations. The Rajya Sabha is obliged to make these recommendations within a period of 14 days. If the Rajya Sabha fails to make any recommendations within this period or does not take any action, the bill is considered to have been passed by both the Houses and is transmitted to the President for his assent. Even after the Rajya Sabha returns the bill with certain recommendations within 14 days, it is up to Lok Sabha to accept them or not. In short, the Rajya Sabha can at the most delay the passage of a money bill for a maximum period of 14 days. President's assent. After a bill is passed by the Parliament, it is presented to the President for his assent. In the case of money bill, the assent of the President is just a formality. In case of non-money bills, however, the President may withhold his assent and return the bill for the reconsideration of the Parliament. But if the two houses of the Parliament repass the bill with or without amendments, the President has to append his signature to the bill. The Constitution does not prescribe any time limit within which the President has to communicate his assent. This obviously is a serious drawback insofar as the President can block the passage of bill approved by the two houses of Parliament by simply pocketing, viz. Not taking any action on it. Constitutional framework. Committees helpful in parliamentary working. 55. To cope with the increasing work, the Indian Parliament has set up a number of committees. These committees play an effective role in the working of Indian Parliament. The members of these committees are appointed by the Speaker or elected by House from amongst its members. These committees are authorized to call witnesses and collect evidence by asking for official papers and records. Powers of the Parliament. The Parliament of India enjoys extensive powers. These are as follows. Legislative powers. Parliament enjoys the right to legislate on all the subjects enumerated in the Union list as well as the concurrent list. However, in case of subjects in the concurrent list, the states also enjoy similar powers. In case of clash between Union and the state law on a concurrent subject, the Union law gets precedence. But if the state law has been reserved for the President and receives his assent, then state law will prevail. However, Parliament can still encode override such law with a subsequent legislation. It also reserves the right to legislate on the subjects enumerated in the state list. Thus, it can legislate on a state subject in the following conditions. If the Rajya Sabha passes a resolution by a two-thirds majority of its members present and voting, that is necessary to legislate on a state matter in national interest, Article 249. When proclamation of emergency has been made either due to threat to the security of India or breakdown of constitutional machinery in a state, Article 250. If the legislature of two or more states recommend that the Parliament should legislate on a subject included in a state list, Article 252. For implementing any treaty, agreement or convention with foreign countries or any decision taken at an international conference or association, Article 253. In the matter of ordinary legislation, the two houses of Parliament have been placed on a footing of equality and proposals can be initiated in either of the two houses. However, the approval of both the houses is essential to place the bill on the statute book. The differences between the two houses are resolved through Tom's sitting of the two houses where the issue is resolved by majority vote. It is obvious that the arrangement gives a dominant position to Lok Sabha in view of greater numerical strength. Financial powers. The Parliament has been vested with complete control over the finances of the Union government. No expenditure can be incurred on taxes levied without the approval of the Parliament. Though the budget is a formality prepared by the executives, the power to sanction the same rests with the Parliament in the financial sphere. Lok Sabha has been provided a superior position. The Constitution specifically provides that a money bill cannot be introduced in the Council of States, Article 110. After it is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its recommendations. The Rajya Sabha is obliged to return the bill to Lok Sabha within 14 days of the receipt of the bill along with its recommendations. It is up to Lok Sabha to accept those recommendations or not. Controversy regarding money bill. The power to certify any bill as money bill is vested in the Speaker. This power is beyond judicial review. Now there is a debate regarding this unchecked power of the Speaker after the Aadhaar Act got passed as the money bill in 2016. If the Lok Sabha accepts the recommendations of the Rajya Sabha, the money bill is deemed to have been passed by both the houses with the amendments recommended by the Rajya Sabha and accepted by the Lok Sabha. However, if the Lok Sabha does not accept any of the recommendations of the Rajya Sabha, the bill is deemed to have been passed by both the houses in the form in which it was passed by the Lok Sabha without any of the amendments recommended by Rajya Sabha.
ఎట్లుంటదంటే ఏళ్ళకి ఇంకంటించుకొని ఓటేసేదాకనే అది మనది పెట్టెలు కట్టదంటే ఇక మనతో రుణం తీరినట్టే 5 ఏళ్ళు పవర్ ఉండే
56. In case the Rajya Sabha fails to return the money bill transmitted to it by Lok Sabha with its recommendations within 14 days, it is deemed to have been passed by both the houses at the expiration of the said period in the form in which it was passed by the Lok Sabha. Thus, it is evident that in the financial sphere, the Rajya Sabha stands at lower pedestal. It can delay the passage of money bill for a maximum period of 14 days. The Rajya Sabha can only touch the purse strings of the nation. It can neither widen its opening nor block the flow from it. The Parliament also keeps an eye on the expenditure of the government through its committees like the Public Accounts Committee, Estimates Committee, etc. Control over executive. In the parliamentary system of government provided under the Indian Constitution, the Council of Ministers, which is the real executive, stays in office as long as it enjoys the confidence of the Parliament. This accountability of Council of Ministers to the Parliament in effect means its accountability to the Lok Sabha. The Parliament reserves the right to criticize the policy of the government and seek information on all matters fallen under the jurisdiction of the Union government. Such control over the ministry is exercised through questions, supplementary questions, resolutions and adjournment motions. In case the Parliament is dissatisfied with the working of the ministry, it can pass a vote of no confidence and compel it to tender its resignation. In actual practice, it is the Council of Ministers which actually controls the Parliament. The Parliament may discuss, debate, criticize and sometimes bitterly attack the policies of the government, but it ultimately approves what is done by the ministry. The rigid party discipline has further reduced the control of the Parliament over the ministry, and the proposals submitted by the Cabinet are readily accepted by the Parliament. Thus, Parliament has virtually become a decision-approving and policy-sanctioning body. General Studies, Mains, Paper I. Constitutional Powers. The Parliament of India has been vested with extensive powers to amend the Constitution. Leaving apart certain provisions of the Constitution and concerning its federal character, the Parliament can amend the Constitution either by a simple majority or by a two-thirds majority of its members present and voting. Further, all the amendments can be initiated only in the Parliament, and the states do not possess any power in this regard. The respective position of the two houses with regards to amendment of the Constitution, the houses have been given equal powers. Miscellaneous powers. The Parliament also possesses extensive miscellaneous powers which do not fall in any of the enumerated category of powers discussed earlier. These miscellaneous powers are discussed below. 1. It elects the Vice President of India and can initial removal proceedings against the President. All the elected members of the Parliament take part in the election of the President along with the elected members of the state legislative assemblies. E. The Parliament also enjoys the power to recommend the removal of judges of Supreme Court and High Courts to the President. E. The proclamation of emergency made by the Parliament also needs the approval of the Parliament. Unless the Parliament accords its approval, the emergency ceases to operate after 30 days of proclamation. IV. The Parliament can assume power to legislate on any subject in the state list if the Rajya Sabha passes a resolution by a two-thirds majority of its members present and voting. Though initially, such a resolution is valid only for a period of 1 year, but its duration can be further extended by 1 year at a time. V. The Parliament can create new All India services on basis of the resolution passed by Rajya Sabha to this effect. This obviously gives greater control to the central government over the administration of the state. With regard to both these powers, the Rajya Sabha has been given a position of priority. An analysis of powers of Indian Parliament shows that it has indeed been vested by extensive powers. But its real importance lies in the important role it plays in controlling the government and getting the public grievances ventilated and redressed. Constitutional Framework 57. Privileges and Immunities of Parliament. Article 105 provides for immunities and privileges of Parliament and its members. The most distinctive feature of immunities and privileges is its ancillary character, which is necessary to ensure the effective functioning of Parliament. Important immunities and privileges of MPs are discussed below. Freedom of speech. Under Article 105, no member of Parliament can be questioned in a court of law for whatever he said or revealed in the Houses of Parliament or committees thereof or even outside Parliament with the authorization of the House. This freedom is subjected to following two limitations. I. Rules of procedure of the House. E. No discussion can take place on the conduct of a judge of the Supreme Court or that of the High Court, except upon a motion seeking his removal. Freedom from arrest. No member of Parliament can be arrested 40 days prior to and 40 days after a Parliament session on a civil case. This immunity does not extend to criminal cases, contempt of court cases and preventive detention cases. Freedom from jury services. No member of Parliament can be compelled to deliver jury service when Parliament is in session. Important immunities and privileges of houses are: 1. Right to exclude an outsider from its proceedings. I. Right to publish or not to publish its proceedings. E. Right to punish individuals for contempt of Parliament. Sovereignty of the Indian Parliament. Scholars have often tried to draw a comparison between the Indian Parliament and the British Parliament. The position of the two parliaments fundamentally differs. The British Parliament is considered to be a sovereign body insofar as there do not exist any legal restriction on its authority. The Indian Parliament cannot advance any such claims. The Indian Parliament cannot claim to be a sovereign body due to following reasons. The Constitution provides the federal structure for the country, in which the powers have been distributed between the Union and the state governments. The central government has the exclusive power to legislate on the subject in Union list, while the state enjoys exclusive powers on the subject in the state list. As both the center and the states draw their powers from the same source, the Constitution, none of them can claim to be superior. On the other hand, in England, all the powers are vested in center and units draw their authority from the center, which also reserves the right to withdraw them at will. The written character of Indian Constitution is another limitation on the authority of the Parliament. The Parliament has been given specific powers by the Constitution and it has to operate within the prescribed sphere. No doubt under certain circumstances, the Parliament can also legislate on the subjects listed in the state list, but it has to operate within the limits prescribed by the Constitution. Parliament is not free to amend all the provisions of the Constitution. Some of the vital provisions of the Constitution concerning the federal character of the Constitution can be amended only with the approval of the state legislatures. The presence of the doctrine of judicial review also restricts the sovereignty of Indian Parliament. The Supreme Court of India has been authorized to examine the constitutionality of laws enacted by the Parliament and to declare them as unconstitutional, if they contravene the provision of the Constitution. The incorporation of a chapter on fundamental rights in the Constitution also restricts the power of Parliament. While enacting laws, the Parliament has to ensure that it does not infringe the fundamental rights of the citizens due to the fear of such laws being declared ultra vires by the courts. '58. General Studies, Mains, Paper 2. In view of the above limitations and restrictions, it can be observed that the Indian Parliament cannot claim to be a sovereign body as in case of British Parliament, because Indian Parliament works on the principle of constitutionalism law. The doctrine of limited government. Parliamentary proceedings. Parliamentary proceedings are carried out by various sessions, devices and motions. Sessions of Parliamentary Proceedings. Article 85 of the Constitution of India provides for sessions, prorogation and dissolution of the Parliament. These are given as under. Sessions of Parliament. The President shall from time to time summon each House of Parliament to meet at a time and place as he thinks appropriate. But the right of the President to summon the House is subject to the condition that 6 months should not intervene between its last sitting in one session and the date appointed for its sitting in the next session. At the commencement of the first session after the general election to the Lok Sabha and at the commencement of the first session of every year, the President shall address both the Houses of Parliament assembled together and shall inform the causes of its summon. It is not a private speech of the President. The speech is prepared by the Cabinet. Extension. Prorogation merely ends a session. Prorogation does not end the life of the House. The House meets again after prorogation. The power to discontinue the House is vested in the President. In England, prorogation brings to an end all bills or business pending before the House. But in India, a pending bill or business does not lapse on the prorogation of a session. It only means that the House ceases to do a business at a particular time. It takes up pending business for consideration, when it meets after. Prorogation. An adjournment terminates a sitting of the House. It is an act of the House and is exercised by the presiding officer at any time. An adjournment does not affect the incomplete work. The House may resume its business when it meets again after the adjournment. Dissolution. A dissolution ends the very life of the House and general election must be held to elect a new Lok Sabha. It is the Lok Sabha which is subject to dissolution. The Rajya Sabha is a permanent body and is not subject to dissolution. A dissolution ends the very life of the House while a prorogation ends a session. The power to dissolve the Lok Sabha is vested in the President. But in this respect also, he acts on the advice of the Prime Minister. In England, the sovereign can dissolve the House when advised by the Prime Minister. This is well-settled convention in England. The position in India is the same. So long as the Prime Minister and his cabinet enjoys the confidence of the Lok Sabha, the President is bound to dissolve the House when advised by the Prime Minister. Devices of parliamentary proceedings. Question hour. The first hour of every parliamentary sitting is slotted for questions hour. During this time, the members ask questions and the ministers usually give answers. The questions are of 3 kinds, namely, starred, unstarred and short notice. A starred question, distinguished by an asterisk, requires an oral answer and hence supplementary questions can follow. Black circle and unstarred question on the other hand, requires a written answer and hence, Supplementary questions cannot follow. A short notice question is one that is asked by giving a notice of less than 10 days. It is answered orally. TTTUTIONAL Framework. 59. Motions of parliamentary proceedings. A brief description of various types of motions has been given below. Closure motion. It is a motion moved by a member to cut short the debate on a matter before the House. If the motion is approved by the House, debate is stopped forthwith and the matter is put to vote. There are 4 kinds of closure motions. 1. Simple closure. It is one when a member moves that the matter having been sufficiently discussed be now put to vote. 2. Closure by compartments. In this case, the clauses of a bill or a lengthy resolution are grouped into parts before the commencement of the debate. The debate covers the part as a whole and the entrepart is put to vote. 3. Kangaroo closure. Under this type, only important clauses are taken up for debate and voting, and the intervening clauses are skipped over and taken as passed. 4. Guillotine closure. It is one when the undiscussed clauses of a bill or a resolution are also put to vote along with the discussed ones due to want of time, as the time allotted for the discussion is over. No confidence motion. Article 75 of the Constitution says that the Council of Ministers shall be collectively responsible to the Lok Sabha. It means that the ministry stays in office so long as it enjoys confidence of the majority of the members of the Lok Sabha. In other words, the Lok Sabha can remove the ministry from office by passing a no confidence motion. The motion needs the support of 50 members to be admitted. Privilege motion. It is concerned with the breach of parliamentary privileges by a minister. It is moved by a member when he feels that a minister has committed a breach of privilege of the House or one or more of its members by withholding facts of a case or by giving wrong or distorted facts. Its purpose is to censure the concerned minister. Motion of thanks. The first session after each general election, and the first session of every fiscal year is addressed by the President. In this address, the President outlines the policies and programs of the government in the preceding year and ensuing year. This address of the President, which corresponds to the speech from the throne in Britain, is discussed in both. The motion is put to vote. This motion must be passed in the House. Otherwise, it amounts to the defeat of the government. This inaugural speech of the President is an occasion available to the members of Parliament to raise discussions and debates to examine and criticize the government and administration for its lapses and failures. Calling attention motion. It is introduced in Parliament by a member to call the attention of a minister to a matter of urgent public importance, and to seek an authoritative statement from him on that matter. Like the 0 hour, it is also an Indian innovation in the parliamentary procedure and has been in existence since 1954. However, unlike the 0 hour, it is mentioned in the rules of procedure. No day yet named motion. It is a motion that has been admitted by the Speaker but no date has been fixed for its discussion. The Speaker, after considering the state of business in the House and in consultation with the Leader of the House or on the recommendation of the Business Advisory Committee, allots a day or days or part of a day for the discussion of such a motion. Censure motion. It should state the reasons for its adoption in the Lok Sabha. It can be moved against an individual minister for specific policies and actions. If it is passed in the Lok Sabha, the Council of Ministers need not resign from the office. Adjournment motion: when there is an urgent matter of public importance, then a member may purpose that the business of the House be adjourned for discussing that matter. This motion can be moved only with the consent of the Speaker. Generally, such motions are discussed in the afternoon at 4 p.m. Other devices of parliamentary proceeding. Half an hour discussion: it is meant for discussing a matter of sufficient public importance, which has been subjected to a lot of debate and the answer to which needs elucidation on a matter of fact. The Speaker can allot 3 days in a week for such discussion. There is no formal motion or voting before the House.
MP వచ్చాకి 10 రూపాయలు కదా
60.
ఎంపీటీసీ
Short duration discussion: it is also known as 2-hour discussion, as the time allotted for such a discussion should not exceed 2 hours. The members of the Parliament can raise such discussions on a matter of urgent public importance. The Speaker can allot 2 days in a week for such discussions. There is neither a formal motion before the House nor young. This device has been in existence since 1953. Point of order: a member can raise a point of order when the proceedings of the House do not follow the normal rules of procedure. A point of order should relate to the interpretation or enforcement of the rules of the House or such articles of the Constitution that regulate the business of the House, and should raise a question that is within the cognizance of the Speaker. It is usually raised by an opposition member in order to control the government. It is an extraordinary device as it suspends the proceedings before the House. No debate is allowed on a point of order. Special mention: a matter which is not a point of order or which cannot be raised during question hour, half an hour discussion, short duration discussion, or under adjournment motion, calling attention notice, or under any rule of the House, can be raised under the special mention in the Rajya Sabha. Its equivalent procedural device in the Lok Sabha is known as notice, mentioned under Rule 3771. Lame duck session: it refers to the last session of the existing Lok Sabha, after a new Lok Sabha has been elected. Those members of the existing Lok Sabha who could not get re-elected to the new Lok Sabha are called lame ducks. Erosion of the credibility of the Parliament. Several factors have contributed to the decline in the prestige and functioning of the Indian Parliament. Some of these are discussed below. Delegated legislation: the growth of delegated legislation is perhaps the most important factor for the decline of Parliament. In the present-day world, it is not possible for the General Studies, Mains, Paper 2, Parliament to devote its entire time to the details of soft legislative measures. It could at best lay down broad policy and leave the rest to be taken up by the executive. Hence, all the bills contain a clause empowering the government to frame necessary regulations and laws. Thus, delegated legislation mutes the Parliament to a great extent, including the law-making power, resulting in the decline of the prestige of the Parliament. The primary duty of the members of Parliament is to enact laws. But in the Indian context, these popularly elected representatives are expected to perform so many varied tasks that their role has become highly complex and multifaceted. In Parliament, The issues coming up for discussions cover a wide range of national and international affairs. Thus, a parliamentarian is expected to be a jack of all the trades. Political conditions. The ever-changing political and moral conditions in India are also responsible for the decline in prestige and position of the parliament. Dominance by the party, the lack of party organization, the malice of political defections, corruption and the decline in morale of the politician have all contributed to the erosion of the prestige of parliament. A major threat to the parliament in India is especially posed by the growth of diverse and divisive forces in all the political parties. Presiding officer. The gradual loss of confidence in the impartiality of the presiding officers of the legislature also is the point of importance. There was time when these officers were highly respected, impartial non-party men. But of late, they have shown an inclination to side with the government and the ruling party, almost functioning as their representatives. Lack of quorum. Lack of quorum is a normal thing nowadays. There is no interest in life left after question hour and 0 hour. Bills are passed often without a quorum. Members should raise and take objections about the quorum, otherwise the bill is deemed to have been passed. Constitutional framework. 61. Dominance of executive. If the government is headed by strong prime minister having big majority in the House, then it is the government which decides the course of proceedings of the parliament. The collective will of the House, generally, doesn't prevail over the government. If such is the situation, we can imagine the position and the prestige of parliament in India. In theory we have a parliamentary system, but in reality the powers of parliament have passed into the hands of the executive. Relationship between Lok Sabha and Rajya Sabha. The framers of the Constitution did not intend to place two houses of the parliament at par with each other. Gopalswamy Iyengar told the Constituent Assembly, the Rajya Sabha was to delay action which might be hastily conceived, but not to prove a clog either to the legislation or to the administration. But the actual working of the Indian Parliament has demonstrated that the Rajya Sabha refused to behave like an initial assistant of the government machinery. This shall be full drawn out by the study of relation between the two houses. Legislative control. In the legislative spheres, Constitutional framework. 61. Dominance of executive. If the government is headed by strong prime minister having big majority in the House, then it is the government which decides the course of proceedings of the parliament. The collective will of the House, generally, doesn't prevail over the government. If such is the situation, we can imagine the position and the prestige of parliament in India. In theory we have a parliamentary system, but in reality the powers of parliament have passed into the hands of the executive. Relationship between Lok Sabha and Rajya Sabha. The framers of the Constitution did not intend to place two houses of the parliament at par with each other. Gopalswamy Iyengar told the Constituent Assembly, the Rajya Sabha was to delay action which might be hastily conceived, but not to prove a clog either to the legislation or to the administration. But the actual working of the Indian Parliament has demonstrated that the Rajya Sabha refused to behave like an initial assistant of the government machinery. This shall be full drawn out by the study of relation between the two houses. Legislative control. In the legislative spheres, both the houses of Parliament have been placed on equal footing by the Constitution. An ordinary bill can originate in either house, but must be approved by both the houses before it can reach the statute book. The differences and disagreements between two houses can be resolved only through joint sitting of the two houses convened by the President. At such a joint sitting, the decisions are taken by a majority vote. This obviously gave the Lok Sabha an advantage over the Rajya Sabha on account of its larger membership. Further, such joint sessions are presided over by the Speaker of Lok Sabha. Sometimes at such joint sitting, the decision can be in favor of Rajya Sabha as well. This can happen if the members of the Lok Sabha are sharply divided over an issue and the members of the Rajya Sabha are united on same point. So far there have been only 3 joint sittings of the houses. The first such joint sitting was held in 1961 in view of differences over the Dowry Prohibition Bill, and the second in 1978 to resolve the difference on the Banking Service Commission Repeal Bill 1977, and third for POTA in 2002. Financial control. In the financial sphere, the Constitution clearly accords preeminence to the Lok Sabha. It provides that money bills can originate only in Lok Sabha. After a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its consideration. The Rajya Sabha is given 14 days to make its recommendations on the bill. However, it is up to the Lok Sabha to accept the recommendations or not. In case the Rajya Sabha fails to make the necessary recommendations within 14 days, the bill is deemed to have been passed by the Rajya Sabha in the same form as was passed by the Lok Sabha and is submitted to the President for his assent. Likewise, if the Lok Sabha does not accept the recommendations of the Rajya Sabha, it can send the bill in its original form to the President for his assent. The right to vote demands for grants is also the exclusive prerogative of the Lok Sabha, and the Rajya Sabha has no say in this regard. In short, in a financial sphere, the Rajya Sabha enjoys an inferior position. It can only delay a money bill for a maximum period of 14 days. Administrative control. In the matter of control over the executive also, the Rajya Sabha enjoys an inferior position. The Council of Ministers is collectively responsible to the Lok Sabha and stays in office as long as it enjoys the confidence of the majority of members of the Lok Sabha. The Lok Sabha can expel the Council of Ministers by passing a vote of no confidence. Further, the members of the Lok Sabha can exercise control over various ministries by raising questions with regard to the activities of various departments and highlighting their lapses. The Rajya Sabha also enjoys the right to criticize the policies and the actions of the Council of Ministers and can also seek necessary information from them with regard to various government activities. But its control is rendered ineffective on account of absence of power to vote out a minister. In this respect, the Rajya Sabha certainly stands at a lower pedestal than the Lok Sabha. 62. General Studies, Mains, Paper 2. Constitution.